Good day, class. I'm attorney Jig Paler-Acasio, and I will be your professor for CLJ 3, Criminal Law Book 1. So, we will be talking about penal laws, specifically those provided under the revised Penal Code. So, when you say criminal law, that is the branch or division of law which defines crimes, treats of their nature, and provides for their punishment. Now, when you say a crime, that is an act committed or omitted. So, an act or omission in violation of a public law forbidding or commanding it. Now, what are the sources of Philippine criminal law? So we have the revised Penal Code, Act number 3815 and its amendments, and we have special penal laws. Now for this subject, we will be covering Book 1 of the revised Penal Code. So actually, the revised Penal Code is divided into two. We have Book 1 and Book 2. For this subject, we will be covering Book 1. Okay. Now, who has the power to enact penal laws? So when you talk about penal laws, these are laws that provide for punishment. So it is only the legislative branch of the government that can enact penal laws. So while the president may define and punish an act as a crime, such exercise is not executive but legislative in nature. So the power to enact penal laws comes from the police power of the state. So the police power vested in the legislature of the state to make, ordain, and establish laws for the good and the welfare of the Commonwealth and of the subjects of the state. Okay. Now, what are the limitations of the power of Congress to enact penal laws? So, first, it must be general in application. So, what do you mean general in application? It must apply to all people who are sojourning in the Philippine territory. So, it cannot only apply to certain types of people. Second, it must not partake of the nature of an ex post facto law. So what is an ex post facto law? It's actually a law which makes a criminal act done before the passage of the law punishable. So for example, we create a law punishing those who do not wear mask. Now the law was enacted on February 1. But in the said law, it states there that those who do not wear masks starting March of 2020 until the enactment of this law shall also be punished. Now that is what you call an ex post facto law, punishing an act which during the time of the commission was not yet punishable by law. There was no law punishing it. An ex post facto law is not allowed under our constitution, and that is one of the limitations of the power of the Congress to enact penal laws. Second, it must not partake of the nature of a bill of attainder. What is a bill of attainder? It is a law which inflicts punishment without trial. So there is always the constitutional right of the accused to be innocent until proven otherwise. So bill of attainder is not allowed, wherein the fact that a person commits a certain infraction of the law, he is already inflicted with punishment despite not having to undergo trial. So that is a violation of our due process. So that is why that is also a limitation of our penal laws. And lastly, it does not impose a cruel and unusual punishment or excessive fines. So it is always, we always go for humane punishment. for our criminal laws. Okay. Now, because of these limitations, our Constitution also sets limitations in the enforcement of our penal laws. Under the 1987 Constitution, Article 3, the Bill of Rights, there it lists down the rights of the accused. No, so as I have said earlier, one of the known rights of the accused is to be presumed innocent until proven guilty. Okay, and then all persons shall have the right to a speedy disposition of their cases. No person shall be held to answer for a criminal offense without due process of law. That is why a bill of attainder is not allowed. All persons, except those charged with offenses punishable by reclusion perpetua, shall before conviction be bailable by sufficient sureties or be released on recognizance as may be provided by law. So it means that there is a right to bail, except under the provisions provided by law. And that no person shall be compelled to be a witness against himself. So that is the right against self-incrimination. So the person cannot be forced to be a witness against himself unless he pleads guilty. Okay. So what is the characteristics? What are the characteristics of our criminal law? Or what are the main features of the Philippine criminal law? There are three main features. We have generality, territoriality, and prospectivity. So when you say general, our Philippine criminal law is general. It is binding to all persons who live or sojourn in the Philippine territory. So, who live, meaning residents, resident aliens, and resident citizens. So when you say resident aliens, these are foreigners who are already living in the Philippines. Or sojourn. When you say sojourn, they are just passing by, but they are in the Philippine territory. So it also applies to people who sojourn in the Philippines. So, however, there are exceptions to the general application of criminal law. So, what are these exceptions? Number one are principles of public international law. So, according to public international law, there are certain persons who are exempt from criminal laws. So, we have sovereigns and other chief of states. So when you say sovereigns, we have our king and queen, we have our monarchs, chief of state, we have our president, our prime ministers. So these people are exempted from the general application of criminal law. We also have our diplomats, the ambassadors, ministers plenipotentiary, ministers residents in charge of the affairs. These are our diplomats. These are foreigners who are within a certain state or within the Philippines, but are covered by their own criminal law. So they cannot be prosecuted for criminal law in the Philippines, but they may be prosecuted in their own state. So that is one exception of the generality feature. Second, we have treaties. Now, treaties can also be an exception to the general application of criminal laws. For example, we have the basis agreement between the Philippines and the U.S., wherein the U.S. military cannot be criminally charged. Here in the Philippines, they may be charged in the U.S. courts and they may be imprisoned in the U.S. And then we have laws of preferential application. For example, Republic Act 75, that is in favor of diplomatic representatives and their domestic servants, wherein again those who are working within the embassy, they are covered by the laws of the embassy of this embassy or laws of the state where the embassy is located, no? So the general application is also not applicable in these cases. Okay, now the next feature of Philippine criminal law is territorial application or territory. So the criminal law is territorial. It means it only punishes crimes committed only in Philippine territory. So the criminal jurisdiction of our Philippine courts is only within our Philippine territory. So we go back to Article 1 of our Constitution, which defines our territory, the archipelagic doctrine, which states that all bodies of water comprising the maritime zone and interior waters bounding different islands comprising the Philippine archipelago are part of the Philippine territory regardless of the breadth, depth, width, or dimension. So the Philippine territory includes the islands and the seas. So when you commit crimes within these areas, you may be prosecuted under the Philippine criminal law. Okay. So, what is the extent of Philippine territory for purposes of criminal law? So, the territory of the country is not limited to land where its sovereignty resides, but also includes its maritime and interior waters as well as its atmosphere. Especially in a country like the Philippines, we are an archipelagic state, so it includes our interior waters. Territorial jurisdiction is terrestrial jurisdiction is a jurisdiction of exercise over land. We have fluvial jurisdiction, that is jurisdiction exercised over maritime and interior waters, and aerial jurisdiction is a jurisdiction exercised over the atmosphere. Now we also exercise jurisdiction in cases of vessels. Okay, so there are foreign public vessels, these are war vessels, and foreign merchant vessels, these are commercial vessels. The war vessels or warships are not covered by our territoriality rule despite the fact that they enter our fluvial jurisdiction, because they are considered an extension of the nationality of the owner of the said vessel, so they cannot be subjected to the laws of the state. Now, a foreign merchant vessel, that is a commercial vessel, when they enter our fluvial jurisdiction, they will be subject to our Philippine criminal laws. So, that is where territoriality comes in cases of foreign vessels. Okay. Now, we also have the rules as to jurisdiction over the crimes committed when you are inside a foreign merchant vessel. So we have the French rule: crimes are not triable in the courts of that country unless their commission affects the peace and security of the territory or the safety of the state is endangered. So despite the fact that a foreign merchant vessel is within the fluvial territory of the state, when the crime does not affect the peace and security of the said state, then they are not covered by the territoriality principle. However, under the English rules, crimes are triable in that country unless they merely affect things within the vessel or they refer to the internal management thereof. In a country, we follow the English rule. So if the disorder only affects the ship, then we cannot interfere. Our courts cannot interfere with the same. However, if it affects other than the ship, then our courts can interfere. Okay. Now, what is the exception of the territorial application of criminal law? So the exception of the territorial application is found on Article 2. Okay, so let's discuss Article 2 later. Article 2 of the Revised Penal Code. Okay, so let's just go back to that later. And lastly, we go to the last feature of our Philippine criminal law, which is prospective or prospectivity. So what do you mean by prospective? There is no crime when there is no law punishing it. All our criminal laws are applied in the future and cannot be applied retroactively. It is applied prospectively. Okay. So, however, there is an exception to the rule. Retroactive effect is allowed if it is favorable to the accused. Now, for example, in a law which punishes the possession of illegal firearms. So, before, such law does not distinguish if you possess a long firearm or the short firearm. Now, it was amended, and the new law then distinguished that if you only possess this kind of firearm, you will have a lower penalty. If you possess this kind of firearm, you will have a higher penalty. Now, those who were convicted of possessing a firearm with a lower penalty, despite being convicted of the past law, it becomes applicable to them because it will shorten their period of imprisonment. So, it will have a retroactive effect if it is favorable to the accused. Or, for example, before, the crime of rape with homicide is punishable by death. But when the death penalty was repealed, the crime of rape with homicide is only punishable with reclusion perpetua or life imprisonment. So, those who were found guilty of rape with homicide during the time that the penalty was death, such law repealing death penalty will have a retroactive effect to these guilty persons because it is favorable to them. It's favorable to the accused. However, the retroactive effect also has an exception. So again, general rule, all criminal laws are applied prospectively except when it is favorable to the accused, except when the accused is a habitual delinquent or it is expressly made inapplicable to pending actions. So, for example, the law is favorable to the accused. However, the accused is a habitual delinquent. When you say habitual delinquent, he has been doing crimes over and over again. So, the retroactive effect will not be applicable to him. Or second, when it is expressly made inapplicable to pending actions. When the said law specifically states that this law shall not apply to pending actions. Okay. Now, what are the basic maxims in criminal law? So, number one, we have the doctrine of pro reo doctrine, wherein it states that where doubt exists, the penal law must be interpreted liberally in favor of the accused and strictly against the state. So, whenever a penal law is to be applied, there are two interpretations in the application of the said penal law. One is lenient to the offender and one is strict to the offender. The interpretation which is lenient or favorable to the offender will be adopted. Okay, so that is the doctrine of pro reo, and it is in consonance with the fundamental rule that all doubts shall be construed in favor of the accused, inconsistent with the presumption of innocence of the accused. But this is only peculiar or applicable in criminal law. So we also have the basic the maxim nullum crimen nulla pena sine lege. There is no crime when there is no law punishing the same. So as I have said a while ago in Prospectivity, when a law is enacted today, it can only be applied the day after, and it could not be applied to punish all the acts that has been done before the enactment of the law, because there is no crime when there is no law punishing it. And lastly, one of the common or the basic maxim of criminal law is actus non facet reum nisi mens sit rea. The act cannot be criminal where the mind is not criminal. So this is only true to a felony characterized by dolo, the intent. So there must always be the criminal intent. However, this maxim is not applicable to felonies resulting from culpa or negligence. Okay, so now we go to the revised penal code. So the revised penal code, again, it consists of two books. Book 1 talks about the basic principles affecting criminal liability and the provisions on penalties. And then we have book 2, which is another subject for criminology students. It defines felonies with corresponding penalties classified and grouped under 14 different titles, though that is for another subject. So we have Article 1, time when the Act takes effect. This code shall take effect on the first day of January 1932. So it means that the revised penal code was enacted and took effect on January 1, 1932. So this law is quite old. However, we are still using the revised penal code up to this very day. Okay, so let's go to Article 2. Article 2, as I have said, is an exception to the territorial principle of criminal law. So what is Article 2? Okay, so Article 2 states that except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago, including its atmosphere, its interior waters, and maritime zone, but also outside of its jurisdiction against those who. So this is an exception to the territoriality rule. Number 1, should commit an offense while on a Philippine ship or airship. So what do you mean by this? For example, you are on board a for example, Philippine Airlines, that is an airship registered under the Philippine government. So despite the fact that you are on board that plane and you do not know the exact territorial jurisdiction in the atmosphere, when you commit an offense on board a Philippine ship or airship, you may be prosecuted under our Philippine criminal laws. So even if you killed a person in a Philippine registered ship in the high seas, you can still be prosecuted in the Philippine courts. That is what Article 2, Paragraph 1 means. Second, should forge or counterfeit any coin or currency note of the Philippine Islands or obligations and securities issued by the government of the Philippine Islands. Now, for example, you create fake money, and the fake money was created somewhere in a different country. So, despite the fact that you created the fake money money in a different country, you can still be prosecuted under the Philippine courts because that is an exception of the territoriality rule under Article 2, Paragraph 2. So it's either you falsify or you forge a coin, a currency note, our paper bills, or obligations and securities issued by the government of the Philippines. We have treasury bonds, we have lotto tickets. So these are examples of obligations and securities issued by the government of the Philippines. Third, should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. So for example, you forged or counterfeited fake paper bills, fake 1,000 peso bills somewhere in country X, and you brought these fake 1,000 peso bills to the Philippines, then you can be held liable. No, even if you did not personally bring it to the Philippines, you just sent it through a courier, and you are still in country X, you can be prosecuted in the Philippine criminal courts. Number 4, while being public officers and employees should commit an offense in the exercise of their function. So what do you mean by this? For example, public officers or employees who are employed at a Philippine embassy in the U.S. So they are in the U.S. territory. However, they are employed in the Philippines because they are working in the Philippine embassy, and they committed an offense of corruption in the Philippine embassy in the U.S. Can they be prosecuted here in our Philippine courts? The answer is yes, because under Article 2, Section 4, if you are an officer committing an offense in the exercise of your function, even if you are not in the Philippine territory per se, then you can be prosecuted in our criminal courts. And lastly, should commit any crimes against national security and the law of nations defined in Title 1 of Book 2 of this code. So what are these crimes? When you commit the crime of treason, inciting to war, inciting to treason, or loss of nation, you have terrorism, genocide. So you can be prosecuted here in the Philippine courts or for any court for that matter. So that is Article 2. Okay. Now let's go to Article 3. We have definitions. So acts and commissions punishable by law are considered felonies. So when you talk about crimes that are punishable under the revised penal code, we call them felonies or delitos or delicts. Okay. So again, felonies are acts or omissions punishable by the revised penal code. So felonies that are committed not only by means of deceit or dolo or by means of fault or culpa. So when you say dolo, that those are considered intentional felonies, while culpable felonies or by means of imprudence, negligence, these are wrongful acts that were not considered intentional, so they are considered culpable felonies. Okay, so when can you consider that there is deceit? When the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. So when you say act, there is an overt or an external act. When you say omission, the failure to perform a duty required by law. So again, felonies are not just acts but are also omissions. Okay. So how do you classify a felony? As we have said, we have intentional felony committed by means of deceit or dolo, and culpable felonies committed by wrongful acts resulting from imprudence, negligence, lack of foresight, and lack of skill. Okay. So, what are the requisites for a crime or for a felony to be considered an intentional felony? So, when there is deceit, when an act is performed with deliberate intent. So, what are the requisites for for a felony to be considered an intentional felony? So, there must be freedom, intelligence, and intent. Meaning, you were free to do the act, you were aware of the act, and it was intentional on your part to do such act. Freedom, intelligence, and intent constitutes a intentional felony. So what are examples of these intentional felonies? We have murder, the act of killing a person. We have treason, the act of what do you call this? Traitor. You traitor your state. We have robbery, the act of getting a person's property. Okay. So we also have culpable felonies. So these are felonies committed by means of fault, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. So when you say imprudence, there is deficiency of action. There was lack of action, no? For example, a person driving a truck and he hit another person because it was raining or it was dark. So that is reckless imprudence. When you say negligence, that is the deficiency of perception. Danghag, tanga, that is negligence. So the failure to foresee an impending danger and usually involves lack of foresight. Now, what are the requisites of culpable felony? So there was freedom to do the act. There was intelligence. You know the act. However, there was no intent to do so. There was either imprudence, negligence, lack of skill or foresight, and lastly, there was lack of intent. You did not really have the intention to do the criminal act. Okay. So, that is the difference between intentional felony and culpable felony. Okay. Now, we have always been talking about intent. What is intent? That is the determination to do a certain thing, an aim or purpose of the mind. It is the design to resolve or determination by which a person acts. So, when you say there is intent, you're already determined to do such thing. Okay? But when you say discernment, it is the mental capacity to tell right from wrong. This is the requisite of intelligence. You have discernment. You know, you have the ability to distinguish right from wrong. Now, you compare also intent and motive, because sometimes motive is also looked into in criminal cases. Now, intent is demonstrated by the use of particular means to bring about the desired result. In intent, there are actually overt acts. Now, your intent to kill is coupled by an action. So that is intent. It is not just a mere state of mind. Compare it to motive. It is a state of mind, and it is the moving power which impels one to do an act. No, so sometimes a motive is looked into again in criminal cases. And when there is a motive in the commission of a crime, it always comes before the intent. So, motive first and then the intent. But a crime may also be committed without a motive. Okay. So, again, criminal intent is the basis of the act and not on the motive. Okay. Let's go to Article 4. Criminal liability. Okay. So, criminal liability may be incurred by any person committing a felony, a delito, although the wrongful act done be different from what he intended, and by any person performing an act which would be an offense against persons or property, were it not for the inherent possibility of its accomplishment or on account of the employment of inadequate or ineffectual means. Okay. So before we go to that, I forgot to discuss another distinction of a crime, which is crimes mala inse and mala prohibita. Okay. So, because we already talked about intent. So, crimes mala inse, these are crimes which are wrong from their very nature. So, for example, murder and homicide, these are crimes mala inse because these are actually naturally wrong. Now, it is really wrong to kill a person. So, that is mala inse crime. And mala inse crimes have a serious effect on society. Okay. While crimes mala prohibita or mala prohibitum is these are penalized by special laws or ordinances, and good faith is not a defense because a crime of mala prohibitum or mala prohibita is not inherently wrong. It is only wrong because it is prohibited by law. So, for example, not wearing of helmet, that is not inherently wrong, but that is a crime mala prohibita because it is prohibited by law. So again, in crimes mala inse, criminal intent is necessary because the act is criminally wrong. While in crime mala prohibita, the criminal intent is not necessary because the act per se is not naturally wrong, but it is prohibited by law. That is why it becomes punishable. Crimes mala inse, these are the felonies that are defined and penalized under our revised penal code. So, all crimes under Book 2, these are crimes mala inse, and crimes mala prohibita, these refers generally to acts made criminal by special laws and ordinances. Okay, so let's go back to Article 4. When does a person become criminally liable? Okay, so Article 4 states two cases wherein a person incurs criminal liability. So number one, any person committing a felony, although a wrongful act done be different from which was intended. Okay, so there are three scenarios in this case. Okay, so in this first paragraph, there must be two elements must be present: that the felony was committed, and that the felony committed resulted in the commission of another felony. Okay. So, what were the three scenarios in Article 4, Paragraph 1? We have, number one, error in persona or error in personae. There is mistake in the identity of the victim. So, for example, Mr. A planned to kill Mr. B. So, while Mr. A was waiting in the dark alley for Mr. B, because it was dark, he saw a person pass. He thought that it was Mr. B. So he shoot the said person, and then said person died. When he saw who he killed, it was not Mr. B, but it was Mr. C. Now, While prosecuted, Mr. A alleged the defense that there was a mistaken identity, thus he should not be held criminally liable because he did not intend to kill Mr. C. He only intended to kill Mr. B. So, is Mr. A criminally liable? So, under Article 4, Paragraph 1, yes, he is criminally liable under the principle of error in personae. So, even if the wrongful act done is different from what he intended, because he intended to kill Mr. B, but he killed Mr. C, he can still be criminally liable. Okay, because a felony is committed and the felony committed resulted in the commission of another felony. So that is first incurrence of criminal liability, even if there is a mistake in the identity of the victim or error in persona or personae. Next, we have aberratio ictus. So what is aberratio ictus? There is a mistake in the blow. Okay. So there was a mistake in the blow. So for mistake in the blow. That is when the offender intending to do an injury to one person actually inflicts it on another. So, for example, let's go back to Mr. A, B, and C. So, Mr. A wanted to shoot Mr. B. And while Mr. B and C were together, they were walking, and A wanted to shoot Mr. B, but because of his lack of skill, he instead shoot Mr. C. So he would then Mr. A would then use the defense of aberratio ictus. There was a mistake in the blow. I did not intend to kill Mr. C. I intended to kill Mr. B. However, I was not a sharpshooter, so it was Mr. B who was killed. Can Mr. B be held criminally liable? Yes, he can still be held criminally liable under the principle of aberratio ictus. So even if a person directed the blow to an intended victim, but because of poor aim, the blow landed on somebody else, then the said person can still be held criminally liable. So, under aberratio ictus, the intended victim as well as the actual victim should be both at the scene of the crime. So, instead of shooting Mr. B, he shot Mr. C who was at the back. So, that is an example of aberratio ictus. And in cases of aberratio ictus, there are two felonies, at least two. Number one, the attempted felony on the intended victim. So, Mr. B can file for a crime of attempted or frustrated murder or homicide, and the felony of the unintended victim. So in cases of aberratio ictus, the accused shall be facing two charges. And then the third is praeter intentionem. So, praeter intentionem, the injurious result is greater than intended. So, for example, Mr. A just wanted to box Mr. B. No, he just wanted to box Mr. B. And upon boxing Mr. B fell on the ground, hit his head on the gutter, and then died due to the head trauma. So, can Mr. A be liable for the death of Mr. B? So, under the principle of praeter intentionem, yes, he can be held criminally liable. Because even if what he only intended was to actually box and inflict injury, and not to really kill Mr. B, but his boxing of Mr. A was the proximate cause of Mr. B falling to the ground and hitting his head and then resulting to his death, then Mr. A can be held liable for the death, criminally liable for the death of Mr. B. So that is praeter intentionem. So in praeter intentionem, the wrong done must be the direct and natural consequence of the felonious act, and there should be no intervening cause. Okay. So and the crime must also be a felony. Okay. So what you did should be a felony in order to be liable under to be criminally liable under praeter intentionem. For example, there was a case wherein a crew of the ship A and B, for example, they were crew of a ship. Now, Mr. A tried to what do you call this? Tried to hit Mr. B with a knife. You know, he tried to cut Mr. B with a knife, and because Mr. B was so scared, he jumped off the ship and he did not know how to swim, and Mr. B drowned to his death. Now, is Mr. A liable? Yes, he is liable because the act of trying to cut someone with a knife is a felonious act that can be considered an attempted homicide, and such act was the direct and natural consequence of the death of Mr. B. So that is an example of praeter intentionem. However, if instead of threatening Mr. B with a knife, for example, he was just tickling Mr. B, Mr. A was just tickling Mr. B, and then Mr. B fell off the ship because of such tickling, then he could not be considered liable under praeter intentionem because there was no intended crime. Tickling a person is not a felony, unlike threatening him with a knife. So that is the difference. Okay. So that is paragraph 1 of Article 4. Now let's go to paragraph 2 of Article 4. It states there that criminal liability shall also be incurred by any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment, or on account of employment of inadequate or ineffectual means. So what is Article 4, Paragraph 2 talking about? That is an impossible crime. So is there such a thing as impossible crime? Yes, that is Article 4, Paragraph 2. So, what is an impossible crime again? It is an act performed which would be an offense against persons or property, and the act was done with all evil intent. However, it was not accomplished because of its inherent impossibility, or the means employed is either inadequate or ineffectual. So, what is the example of an impossible crime? For example, Mr. A wanted to kill Mr. B. So, he knew that open window was the room of Mr. B. So, when midnight came, Mr. A climbed the tree, went inside the room of Mr. B, and then killed Mr. B with a knife. So, he cut the body of Mr. B with a knife, not knowing that Mr. B already died hours ago because of a heart attack. Okay, so while he was killing Mr. B was already dead. So that is an impossible crime of murder. Will Mr. A be punished under such crime even if Mr. B was already dead? Yes, he shall be punished because what is punished in impossible crime is the criminal propensity of the person, the intent of the person to commit a crime even if the crime cannot be committed. So the penalty is actually lower than the actual crime committed, or the intended crime committed, because again, the crime was not consummated. Okay, so that is an example of inherent impossibility, because you cannot kill a dead person. So that is the impossible crime of murder, homicide. Or there was an adequate or ineffectual means. So for example, Mr. A wanted to kill Mr. B through poisoning. Okay, so Mr. A prepared the food of Mr. B and added poison on the food of Mr. B, not knowing that the poison was already expired, or not knowing that it was not actually a poison but just water. It was replaced, the bottle of poison was replaced by water. Now of course, Mr. B did not die out of poisoning, but Mr. A can still be held criminally liable for the impossible crime of murder, because he was planning to kill Mr. B, but the employment of how to kill Mr. B was inadequate or ineffectual. So again, the punishment of impossible crime is what do you call this? The fact that a person really wants to commit a crime, so we have to deter the criminal propensity of such person. Then, lastly, for this lecture, we have Article 5, the duty of the court in connection with acts which should be repressed but which are not covered by law, and in cases of excessive penalties. So whenever a court has knowledge of any act which it may deem proper to repress or which is not punishable by law, it shall render a proper decision and shall report to the chief executive through the Department of Justice the reason which induced the court to believe that said act should be made subject of a legislation. Now, for example, a person committed a certain act and there is no crime and there is no law punishing such act, then the court cannot make a decision punishing that person because he believes that the act should be penalized, because the courts are interpreters of the law. But when there is no crime, when there is no law punishing it, so what the courts will do, the judge shall acquit the said accused and then write a letter to the chief executive stating that said act should be held punishable. Okay, so that is Article 5. Or in the same way, the court shall submit to the chief executive through the Department of Justice such statement as may be deemed proper without suspending the execution of sentence. The strict enforcement of the provisions of this code would result in the imposition of a clearly excessive penalty, taking into consideration the degree of malice and injury caused by the offense. So, for example, we have the crime of theft of coconuts. So, if you try to look at Book 2, theft of coconut is classified as qualified theft. So even if you already you stole one coconut, you could be held liable for qualified theft, which has higher punishments compared to theft. So what the courts will do, if they think that the penalty is already excessive, they may again write to the chief executive and inform the chief executive through the Department of Justice that the penalty is excessive. Okay, so those cover the general provisions of criminal law, Article 1 until Article 5. So thank you so much and goodbye. Have a good day.